Brett Kavanaugh confirmation updates abortion, guns and stolen emails. Judge Brett M. Kavanaugh is before the Senate Judiciary Committee for the second day of his Supreme Court confirmation hearing, defending his judicial independence. Senators Charles E. Grassley of Iowa and Dianne Feinstein of California, the top members of the committee, went first, feeling out Judge Kavanaugh's judicial independence and his views on guns and abortion. Each senator has 30 minutes to interrogate Judge Kavanaugh. Protests are intermittent. On stolen Senate emails and Kavanaugh's knowledge of them. Senator Patrick J. Leahy, Democrat of Vermont, raised two Bush-era scandals with Judge Kavanaugh, and he suggested that Bush White House emails in the Judiciary Committee's possession may contradict testimony the nominee made more than a decade ago if only they could be released publicly. The exchange was tantalizing but incomplete. One of the scandals was the disclosure in late 2003 and 2004 that a Republican Judiciary Committee staff member had infiltrated the Democrats' confidential internal files about which of President George W. Bush's judicial nominees, to try to block and with what tactics. The other was the disclosure that after the September 11, 2001, terrorist attacks, the Bush administration had secretly ordered the National Security Agency to intercept Americans' phone calls and emails without obtaining the judicial warrants seemingly required by the Foreign Intelligence Surveillance Act. At his appeals court confirmation hearing in 2006, Judge Kavanaugh, who had worked as an associate White House counsel in the Bush administration, told senators that he did not know anything about the infiltration of Senate Democrats' files on judicial nomination fights or about the warrantless wiretapping program before they eventually became public. Continue reading the main story. But Mr. Leahy indicated that documents marked committee confidential show that Manuel Miranda, then a Republican staffer on the Judiciary Committee, had sent Judge Kavanaugh emails about Mr. Leahy's private concerns about a judicial nominee whose hearing was coming up and a draft letter Mr. Leahy had not yet sent. He also suggested that the files may show that Mr. Miranda made a reference to having a mole on the committee or spying on Democrats, and that Mr. Miranda may have suggested meeting outside of their workplaces. The senator also indicated that Mr. Kavanaugh may have had some involvement with a memo written by John Yoo, who was an attorney in the Justice Department's Office of Legal Counsel, who wrote opinions secretly blessing the surveillance program was lawful. Judge Kavanaugh insisted that everything he had testified before was 100% accurate, but indicated that he was not sure what Mr. Leahy was referring to. Mr. Leahy asked Mr. Grassley to lift the confidentiality protections over the emails in question so he and Judge Kavanaugh could discuss them in his second round of questioning, and Mr. Grassley indicated he would look at them. I am concerned because there is evidence that Mr. Miranda provided you with materials that were stolen from me, Mr. Leahy said. And that would contradict your prior testimony. It is also clear from public emails, and I'm refraining from going into non-public ones, that you had reason to believe materials were obtained inappropriately at the time. Kavanaugh says he'll respect abortion's precedent on precedent. Judge Kavanaugh, under attack from progressives and Democrats who say he will roll back abortion rights, asserted that he understood the significance of the issue and would respect the Supreme Court's precedent on precedent. I don't live in a bubble, I live in the real world, he said, after Ms. Feinstein reminded him of the death tolls in this country among women who tried to end their own pregnancies before Roe v. Wade. The landmark 1973 decision establishing a constitutional right to abortion. I understand your point of view on that, and I understand how passionate and how deeply people feel about this issue, he said. Senator Feinstein did not ask him the operative question, does he believe Roe was correctly decided? But even if she had, he had already told Senator Grassley it would not be appropriate to answer it. She did ask him what he meant when he told Senator Susan Collins, Republican of Maine, that he believed Roe was settled law. At that, he launched into a discourse on the value of precedent. Judge Kavanaugh said that Roe was settled as a precedent of the Supreme Court, and as such, deserves respect from judges who took note of it. But then he noted a subsequent case, the 1992 case of Planned Parenthood v. Casey, which narrowed the scope of Roe, at the same time that it reaffirmed Roe as a precedent. Casey, which gave states the authority to regulate abortion so long as those regulations do not pose an undue burden on the woman, is precedent on precedent, he said. His comments were a reminder that, as Senator Chuck Schumer, the Democratic leader, has often pointed out, precedents are only settled law until the Supreme Court unsettles them. Democrats complain that previous nominees have pledged to respect precedents, only to narrow or overturn them once seated on the court. Can President Trump pardon himself? Senator Patrick J. Leahy, Democrat of Vermont, put that question directly to Judge Kavanaugh. If Mr. Leahy thought he was going to get a direct answer to the direct question, he was mistaken. The question of self-pardons is something I've never analyzed, Judge Kavanaugh said, adding I can't begin to answer in this context as a sitting judge and a nominee to the Supreme Court. Mr. Leahy pressed anyway, asking whether the president could pardon associates to keep them from testifying against him. Again, Judge Kavanaugh dodged the question, saying that as a judge, he would normally receive briefs and arguments from both sides before coming to a conclusion. I'm not going to answer hypothetical questions of that sort, he said. Can a president be subpoenaed? No comment. Pressed by Ms. Feinstein, Judge Kavanaugh refused to say whether he would rule that the Constitution permits a sitting president to be subpoenaed for testimony. He said that as a matter of judicial independence, he would not give the Senate a precise answer on a hypothetical that might come before me. The potential for a legal fight over a presidential subpoena has become a hot topic amid speculation that Robert S. Mueller III, the special counsel investigating Russia's interference in the 2016 campaign, may issue a subpoena for President Trump. Lawyers for the president and the office of the special counsel have been negotiating for months over whether Mr. Trump will voluntarily sit for an interview, so far without success. In 1974, the Supreme Court unanimously ruled in United States v. Nixon that a sitting president, in that case Richard M. Nixon, could be subpoenaed for documents and records like the Watergate tape recordings. But the court has never addressed the question of whether a sitting president could be forced to answer questions, which raises additional issues about the time it would take to prepare and the potential distraction from carrying out his constitutional duties. Noting that Chief Justice Warren Burger, who wrote the ruling, had been appointed by President Nixon, Judge Kavanaugh said he thought the Watergate tapes ruling was one of the greatest moments in the Supreme Court's history because it stood up for judicial independence in the face of political pressure. But how that precedent would apply to other hypotheticals, like whether a subpoena for presidential testimony in a criminal investigation should also be upheld, was something he should not address, citing the practice of previous Supreme Court nominees. Judge Kavanaugh was a prosecutor working for Ken Starr when the independent counsel issued a subpoena to Mr. Clinton. But Mr. Clinton's legal team negotiated a deal whereby he testified voluntarily before a grand jury, and Mr. Starr withdrew the subpoena, so the issue was never adjudicated. Years later, after working in the Bush administration after the September 11 attacks, Judge Kavanaugh said that he thought presidents should be temporarily shielded from criminal investigation while they were in office, although he left it ambiguous as to whether he thought that was a change Congress should make or that the Constitution might already allow. Kavanaugh cites Nixon to assert his independence. Answering the very first question on Wednesday, from Senator Grassley, the Judiciary Committee chairman, Judge Kavanaugh said he would be an independent justice. He cited 3 Supreme Court landmarks to make his case. 2 were predictable: Brown v. Board of Education, the 1954 decision that ruled segregated public schools unconstitutional, and Youngstown Sheet and Tube Company v. Sawyer, the 1952 decision rejecting President Harry S. Truman's attempt to seize the nation's steel mills to aid the war effort in Korea. The third was notable. United States v. Nixon, the 1974 decision in which Supreme Court unanimously ruled that President Nixon had to comply with a subpoena seeking tapes of his conversations in the Oval Office. Judge Kavanaugh has not always been unequivocal in his support for the decision. In a 1999 transcript of a roundtable discussion, he said, "Maybe Nixon was wrongly decided a heresy, though it is to say so." His allies have said he meant the statement as a critique of the legal strategy of President Bill Clinton's lawyers. On Wednesday, Judge Kavanaugh said the message of the decision, which he called one of the greatest moments in American judicial history, was clear. "No one is above the law in our constitutional system," he said. Kavanaugh says he is not under regulation. An abstract but important part of Judge Kavanaugh's judicial philosophy is his skeptical approach to so-called Chevron deference, the principle that when a statute granting a regulatory agency the authority to make rules about a certain topic, such as protections for the environment, consumers, or workers, are ambiguous, the courts should accept the agency's interpretation that it has the power to make a rule. Corporations opposed to what they see as overly burdensome regulations want the Supreme Court to overturn or narrow the Chevron ruling, making it harder for executive agencies to expand into new areas. Questioned about his view of the powers of administrative agencies by Senator Orrin G. Hatch, Republican of Utah, Judge Kavanaugh touted several rulings in which he had upheld environmental regulations rather than striking them down, but he gave little sign of support for Chevron deference. insisting instead that executive branch agencies must not be permitted to rewrite laws passed by Congress to expand its authority. "I've heard it said that I'm a skeptic of regulation," he said. "I'm not a skeptic of regulation at all. I'm a skeptic of unauthorized regulation, of illegal regulation, of regulation that is outside the bounds of what the laws passed by Congress have said." Sham president, sham justice. The second day of Judge Kavanaugh's hearing started with still more protests just as Senator Grassley opened with the hope that the proceedings would be under more control than Tuesday's divisive opening. One woman was led out shouting "Sham president, sham justice." In his opening remarks, Mr. Grassley accused Democrats who strategized for the hearing on a conference call Monday of colluding with protesters to disrupt the hearing. NBC News reported that Democratic members of the committee plotted with minority leaders to disrupt the hearing yesterday, he said. Democratic senators interrupted the hearing 63 times before lunch, and in the audience, 70 people were arrested yesterday who were following their lead. But one of the protesters took exception to Mr. Grassley's assertion, since, she said, she was calling out Democratic leaders such as Senator Richard J. Dobbin of Illinois for their tepid efforts to thwart the nominee. And a spokesman for Mr. Schumer said there was no coordination. Ken Starr Jew. In the 1990s, as a prosecutor in Mr. Starr's Monica Lewinsky investigation, Judge Kavanaugh supported aggressive questioning of former President Bill Clinton about his sexual relations with the former White House intern. Years later, however, Mr. Kavanaugh expressed regret about that view, suggesting that sitting presidents should not be subjected to the kind of distracting investigations that helped subject Mr. Clinton to as part of the Starr investigation. That shift in views has prompted Democrats to assert that Mr. Kavanaugh would try to protect Mr. Trump from Mr. Mueller's Russia investigation. Ms. Feinstein pressed Judge Kavanaugh on that point on Wednesday. Mr. Kavanaugh said his views changed after he watched former President George W. Bush deal with the September 11 terrorist attacks and their aftermath, and concluded that presidents should not be distracted from important crises like that by having to respond to investigations such as the one that Mr. Clinton faced. September the 11th, that's what changed, he told Ms. Feinstein. He added, however, that his comments about potential changes to the statutes governing investigations of presidents do not reflect his thinking on the question of whether the Constitution would allow such investigations to proceed. If a case came up where someone was trying to say this was a constitutional principle, I would have a completely open mind on that, he said. I gut punch on sexual harassment but no guilt by association. Critics of Judge Kavanaugh have noted that he clerked for a former Ninth Circuit Court of Appeals judge, Alex Kozinski, who has been accused of sexually harassing more than a dozen women. They assert that Mr. Kavanaugh must have known about the allegations long before they were made public. Senator Hatch came to Judge Kavanaugh's defense, calling such accusations against Mr. Kavanaugh guilt by association, but asked a series of gentle questions designed to give the judge an opportunity to deny them. He did just that, seeking to put distance between himself and any hint that he knew of or condoned the judge's behavior. Did you know anything about these allegations against Judge Kozinski? Mr. Hatch asked. Nothing, Mr. Kavanaugh responded, adding a moment later. When they became public, the first thought I had was no woman should be subjected to harassment in the workplace, including in the judiciary, especially in the judiciary. He went on, it was a gut punch for me. It was a gut punch for the judiciary. I was shocked, disappointed, angry swirl of emotions. Overall, Judge Kavanaugh has gone out of his way to extol his record on women. He said he has made an aggressive effort to hire female clerks. 25 of the 48 clerks that Judge Kavanaugh has hired during his 12 years on the appeals court have been women, and 21 have gone on to clerk at the Supreme Court, he told the committee. He said he was spurred to do so by an article in the New York Times by Linda Greenhouse, the newspaper's former Supreme Court correspondent, who wrote in 2006, the same year Judge Kavanaugh joined the court, about the paucity of female clerks on the Supreme Court. Judge Kavanaugh said that troubled him, calling it unacceptable. He hired 3 women out of 4 clerks for his first year on the bench, adding that the next generation of leaders and Supreme Court justices will be drawn from the ranks of that generation. It's something I'm very focused on at all times, he said. Kavanaugh and Osama bin Laden's bodyguard. Judge Kavanaugh held up his ruling in a 2012 appeals court case reversing the military commission's conviction of a former Guantanamo detainee, Salim Hamdan, as evidence that he would be independent and could resist public and political pressure when it came to deciding cases. Mr. Hamdan A Yemeni man who served as a driver and bodyguard to the al-Qaeda leader Osama bin Laden had been convicted in 2008 before a military commission on a charge of providing material support for terrorism. His lawyers challenged the conviction on the grounds that material support was not a recognized international war crime at the time of his actions, and tribunals are generally for war crimes. The Military Commissions Act of 2006 listed that charge as a war crime that the tribunals could handle, but Judge Kavanaugh from the appeals court ruled that it did not apply retroactively and overturned the conviction. You will never have a nominee who has ruled for a more unpopular defendant than ruling for Salima Hamdan, Judge Kavanaugh said. And why did I do that in that case? Why did I rule for someone who had been involved in the September 11th? It's because the law compelled it. Still, Mr. Hamdan, who had already served his sentence and been repatriated back to Yemen by 2012, was not accused of advanced knowledge of or involvement in the September 11th attacks. And in many other important cases involving Guantanamo detainees, Judge Kavanaugh sided with the government, including ruling in ways that made it harder for detainees to win habeas corpus lawsuits challenging the basis for their indefinite wartime detention without trial, arguing that the appeals court had no jurisdiction to hear challenges brought by military commissions defendants before the tribunal issued a final judgment, and maintaining that international law cannot be enforced in court as a constraint against what Congress and the President do with tribunals. A human touch. Judge Kavanaugh, accused by Democrats of being a tool for big corporations and a foe of the little guy, wasted little time in trying to humanize himself on Wednesday. In response to Senator Grassley's first question, about what makes a good judge, he invoked his mother, herself a judge. My mom taught me in the first instance, judging is not just about theory, he said. It's not theory. It's not just what a law review article says. Judging is real people in the real world, and every decision we make, no matter how high-minded it might sound, affects real people with real-world interests. He told the panel amid raucous protests inside the room that civility was important. I've tried to be a very collegial judge. I've tried to be civil, he said, adding that he wanted the losing party in every case to come out and say, Kavanaugh gave me a fair shake. Thank you for watching. For the follow-up, subscribe to the channel.